All right. So today, the judge responded to the City of LaPorte's motion for a change of venue. As you can see, all right, so Nick Otis claims that when I called the court, it was improper ex parte communication, that the court is biased in my favor, and thus the City of LaPorte has experienced some sort of loss due to my tactical advantage, blah, 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 blah. You know, they say that it's sort of run-of-the-mill. Anyway, they address the fact that the City of LaPorte is now claiming that, you know, there is not 13 pages, there is only 12. Clearly that's in confliction with what they previously said. There's not a 13th page missing, it simply does not exist. The city withheld 13 pages of documents in 2018. So either the 12 pages of disclosed incident reports are part of the withheld 13 pages of documents as discussed in the March 23, 2018 response, or they are not. No matter whether the 12 pages of incident reports are part of or separate from those 13 withheld pages, the same result occurs. By respondents' own declarations, there is at least one extra page that has been withheld from plaintiff, to which plaintiff has a right to receive. In his change of venue, he says that the court had not asked the city to respond. They state that that is without a shred of merit or logic. An exhaustive reading of the Indiana Rules of Trial Procedure reveals very particular circumstances when permission of the court is a requisite in a response, none of which apply here. Further, this court can find no instance in the rules or case law where cardinal principles such as judicial efficiency are summarily tossed aside in favor of a default practice of micromanagement by a tribunal. The respondent's counsel's lack of action as solely an issue between a client and its counsel. So basically, it's not this court's responsibility to babysit Nick Otis. Plaintiff's diagnosis of Asperger's spectrum disorder and post-traumatic stress disorder, which plaintiff lists in his filing. This court takes notice of the same established in prior proceedings involving the plaintiff. This court takes pride in its accessibility to all persons in the community, thanks in no small part to the professionalism of its staff. I agree. I concur in full. This court is proud that its staff is capable of maintaining the public's faith in the judiciary by being able to let a person or party vent to the staff without creating a prejudice or other impropriety which may affect the court's decision. Such is the case here. Plaintiff, who is understandably upset, there's nothing in the record or the present motion that indicates the plaintiff attempted to disclose or argue to the chief of staff any point of law or fact that was not already in front of the court or was not a publicly known fact, of which the court was free to take judicial notice. Such oh yeah. In regard to transcribing conversations, a tendentious recitation of the facts. Counsel neglects presenting specific facts that there were no arguments or facts presented in the communications with court staff. Respondent presents a gross misstatement of the facts bordering on a fraud against the tribunal and defamatory against the conversationalist while continuing to step on plaintiff's constitutional rights and violating the state's presumption of transparency. The court does not issue a finding about any of the allegations in the present motion from respondent which point to a violation of professional or ethical conduct. Anyway, change of venue is hereby denied. The court does not find or concede to any of the allegations in respondent's motion. This court does find that the respondent's counsel's antagonism toward the plaintiff, the court, and its staff, as well as misstating the standards in judicial and legal conduct, has created a cyst within this case that taints the judicial process and thus threatens impartiality. Thank you, Judge. Merry Christmas to me.